Farmers and agricultural organizations are seeking a nationwide injunction against a Department of Labor rule that allows foreign farm workers to form unions and make other changes to the H-2A guest worker program. A federal judge in Georgia has already blocked the rule in 17 states, including Idaho. A new lawsuit in the U.S. District Court of Eastern Kentucky seeks to extend that preliminary injunction to all 50 states. WAFLA is one of the organizations participating in that lawsuit filed on September 16th. I recently had a chance to sit down with WAFLA CEO Enrique Gastelum to find out why the organization is part of the lawsuit and what they're hoping to accomplish.
So what has occurred is the Federal Department of Labor with the H-2A program has been pretty aggressive on their rulemaking the last couple of years. They've issued 3 sets of new rules in the course of about 2 years. Prior to that, they had not issued a new set of rules, but going back to 2010. So it's clear the Biden administration, through Department of Labor, is very intent on modifying the H-2A regulations. And this latest round called and under the guise protecting farm workers, farm worker protections, improving farm worker protections. They are really, we believe, overstepping some of the constitutional rights of our farmers, private property rights. They are, we believe, trying to drive a wedge between workers and their employers. And quite frankly, they're getting into not just, we believe, setting regulations for, workers having a safe, workplace where they're, not discriminated against or taken advantage of, but there's some very concerning provisions in these new rules where we believe they're trying to tell the business how to operate their business every single day. And so this new set of rules were proposed November of 2023. There was rulemaking that went on. Many thousands of people, tens of thousands of people responded. DOL slightly modified them, but put the rules in effect in June of this year. They delayed the rollout of them because some of them relate to the filing of H-2A contracts, so they had to update the filing online webpage that employers and agents use to file contracts. So that was delayed until August. What then ended up occurring was there was a group out of Georgia and 17 other state attorney generals, farmers, Georgia Fruit and Vegetable Association, as well as 17 different state attorney generals that filed the actual first, I'll call it, shot across the bow versus Department of Labor and filed a lawsuit calling out 2 issues in particular with these rules. One, stating that farm workers were going to receive rights that Congress had not extended to them, rights to unionize. So they were going to protect all these unionizing type provisions. And currently right now, for different reasons, the federal government exempts farm workers from unionizing protections under the National Labor Relations Act. It has been legislated at the statewide levels, as we've seen in California or New York recently. So through this rulemaking, DOL is extending nationally to both foreign workers and other people that work on these farms protections and rights under the similar type provisions like the National Labor Relations Act. So that's one part of the lawsuit that the original complaint from the Georgia group brought up was that, look, Department of Labor, you're no longer rulemaking, you're trying to create law. That's not your job. That's Congress's job. And then secondly, there was a lawsuit filed in California a couple years ago called the Cedar Point case, and that went all the way up to the federal U.S. Supreme Court that said farmers do have private property rights to know who's on their property, and this was related to labor activists attempting to trespass on farmers' property and visit farm worker housing without farmers' notice or anything like that. Well, that case was tried, went all the way to the U.S. Supreme Court, and the U.S. Supreme Court says, yes, farmers do have the right to know and limit access to people on the farms for various reasons. So this new rule that DOL issued said we're going to grant rights to people to go and visit farm workers under the guise that farm workers can accept and have any guest they want come visit them at the housing. So they guised it as a new right they were extending to the farm workers. So this original case brought both of those up. Fast forward, a judge granted an injunction against Department of Labor that said we believe the claimants have standing. We believe they would prevail in a lengthier trial. And so this judge said, I am staying the entire rule, but I'm only going to cover the 17 states where these plaintiffs are listed in this case. The rest of us, that for the other 33 states, we're saying, okay, well, hopefully Department of Labor will say because it's going to be hard to, implement and enforce two different sets of rules for H-2A nationally, we'll stay the rule nationally. DOL did not do that. They doubled down last week, week of September the 12th or 13th, came out and said, nope, we're going to go ahead and enforce two different sets of rules. We're going to make all these new filing requirements that we never actually went through they didn't say this, but they didn't go through the proper Administrative Procedures Acts, and we're going to go ahead and double down, and those of you in the 33 states still have to follow these new rules. Those of you in the 17 states where this injunction is at, you can follow the old rules. So WAFLA with North Carolina Growers Association, National Council of Ag Employers, a farming group out of Kentucky, and some Kentucky farmers as well as U.S. farmers decided enough's enough. We need to take a stand for the other 33 states. And so we ended up filing suit as well this week on Monday to seek an injunction nationally to cover all the other 33 states. And then we brought up many other issues that we have with these rules beyond just those two I mentioned.
Enrique, people will hear terms like improving worker protection, improving worker safety, and they might say, well, geez, why in the world would you oppose something like that? What would you say to those arguments of, hey, these bills or these rules are just looking at making sure farm workers are safe and that they have a voice?
Yeah. So yes, when you hear that original title, it sounds like this is all great stuff. The problem is the devils are in the details, Glenn. So, for example, one of the provisions in there, and I'm a practical person, all right? Grew up out in farming community, and while rules are great on paper, how do we actually implement them in real life? And I'll paint the picture of just one of them, which actually does have to deal with worker safety, and it's seatbelt use in company or employer-provided vehicles. They're saying they're going to mandate through this rulemaking that employers must ensure all employees are not only provided with seatbelts in vehicles that have seatbelts, but they have to ensure they're used during 100% of operation of the vehicle. Well, that's all great until we get to a point where a farmer who's using the H-2A program has a van that carries, 12, 15 passengers. I ensure all those seatbelts are there. I have a training policy where I ask people to buckle up. I have my driver inspect, make sure everybody is buckled up, but then we start driving. We then go down the road, and unfortunately, accidents can occur for various reasons. Somebody gets an accident, and one or two people are unbuckled. The way this rule is written, that employer is going to be held liable by the Department of Labor for tens of thousands of dollars of citations for not ensuring 100% of people were buckled up. So, again, under the guise of protecting farm workers, yeah, I get that having seatbelts, providing seatbelts is a good thing. We should train people on their use, but we're also dealing with adults here and practical things. How am I able to ensure 100% of the operation, everybody stays buckled up the entire trip? So that's one there. Another thing they put in here was they are mandating formal, systematic, cyclical, progressive disciplinary processes built into employers' HR practices. So let's say a worker's not cutting it this year, or they're lagging behind, or they're being insubordinate, or they're just not being a productive worker, before I'm able to terminate them during the year in a state like Washington, where it's been at-will employment, or Oregon or whatnot, where it's a choice, right? A worker can choose to work and an employer can choose to hire you, and at any point we can part ways. Before I'm able to terminate that worker, I'm going to have to go through a very strict 6-step progressive disciplinary process of documenting, putting the worker on notice, investigating, calling in witnesses. Oh, and also the worker can now invite in a third-party representative of their choosing. We call it phone a friend. Could be an attorney, could be their mom, could be their brother, could be a coworker, could be Joe off the street. I now, as a farmer, I'm trying to discipline somebody in the field for some work. I now have to stop, wait for this third party to potentially come or become an active participant. I have to allow them to, they could speak on behalf of the worker, all before I'm able to terminate this person, and we're in the middle of harvest. So, yeah, Glenn, there's, it's under the title of protecting farm workers, but really what it's doing is it's creating an administrative and, quite frankly, a civil penalty nightmare for our farming businesses. So it's just, to me, conceptually at the highest level, yes, there's some okay concepts in there to improve protections for workers, but it's going to create what I would call an audit nightmare, lots of grenades and traps being set where a farmer can get tripped up. And if anybody's seen citations and violations from Department of Labor, they're not a couple $100. These all start, $5,000-$10,000, and they just go up from there. And in an industry right now, labor-intensive ag is stressed by markets, finances, regulatory burden. To us, we just saw this. This was like just too much for the industry to take right now.
So, Enrique, where do we go from here? And I understand the legal system can move at a glacial pace from time to time, but is there a sense of what sort of steps are going to be taken next and what that timeline might look like?
Yeah, so like in our case, where we're trying to cover the other 33 states, we would suspect we should have a hearing on this and a ruling by a judge anywhere from 2 to 3 months from now, prior to the 2025 year starting off. So while some people that are already starting to file what we'll call early season contracts in the Northwest, they've got to get those filed in October, November this year. We may know soon around that window of time if this injunction is going to be implemented nationally or not, meaning the rules are stayed until further notice, meaning people would keep complying with what they're complying with now. If it's not stayed, then we will have to work through the administrative burden with, farmers will have to work, if they're using the H-2A program, we'll have to work through this administrative burden and make sure they clearly understand these new rules, because it will change the language that goes into their contracts and what they're able to enforce, and new rights extended to workers, and be ready to potentially accept guests at farm worker housing, potentially have workers call in third-party reps whenever they're trying to manage their workforce. And so these are all things that farmers need to get educated on now, should they come into play for next year.
Enrique, obviously this looks like, if this moves forward with the way the Department of Labor wants to go forward, it's going to be very challenging for the farmers. What sort of ripple effect do you see, or do you anticipate this will have on the workers, those who are seeking to come to the U.S. through the H-2A program and work for a summer or a couple of years?
Yeah, I think potentially, we're already seeing rapid farm loss here across the Northwest, right? Washington losing a couple farms a day, consolidation occurring. And I hear regularly from growers, it's the cost of labor and the regulatory burdens, right? Double down with, the market impact. So, if this proceeds and employers have to keep following this, we may see some employers bow out of the H-2A program, which now means, farms getting consolidated. So that now means job loss for, these foreign workers, but I think more severely any local domestic U.S. workers that we still have that are working in labor-intensive ag. Farms shutting down is not a good thing for, not even just the workers, but the local economies and the local communities that are dependent upon these workers coming to the area and producing these products. So, it could create some that what I call the most severe impacts. I think the more minimal death by 1,000 cuts impacts are going to be just employers are going to have these much more complex, need to be robust, complicated HR policies and procedures, and workers may get frustrated because they want to deal with something directly with the employer and do it quickly, but the employer now has to go through all these hoops and documentation, and I think it's going to potentially create some confusion for workers and workers not even understanding, where's all this stuff coming from. So I think it's just going to potentially also create some miscommunications amongst folks and some frustrations on both sides.
Once again, WAFLA CEO Enrique Gastelum.